Good morning, everyone. A very warm and hearty welcome to all our distinguished attendees here in the hall and to all our viewers who are watching us live virtually. Today marks the third chapter in our transformative constitutional lecture series, Vidisat, 75 years of Indian Constitution, Evolution, Challenges and Prospects, organized by School of Law, Graphic Era Hill University. And I would like to take this opportunity to specially thank Dr. Vinay Goyal, our head of the department, for his constant support and guidance for making this lecture series, this event, a reality. British Sattva is a call to awaken the legal spirit within us. It is a space for critical thinking and for creating inquiry and for transformative dialogue on where the Constitution has been and where it must go. As we explore the structural shifts, jurisprudential interpretation, and socio-political evolutions of our constitutional journey, today's session opens a deeply consequential conversation, one on reforms and the future we must dare to imagine. And to lead us through that, we have with us virtually connected a legend in truest sense of the word. It is my privilege and intellectual delight to welcome Senior Advocate Mr. Prashant Bhushan sir, a name synonymous with integrity, public interest law, and a life spent defending the very spirit of constitutional morality. Mr. Bhushan is not only one of India's most formidable Supreme Court advocates, but also a relentless crusader for justice, whether in the courtrooms or on the streets. From landmark public interest litigations to unflinching activism, his contribution to the Indian legal and civil life is of immense. He has fearlessly taken on some of the most powerful forces in the country, armed not with rhetoric but with law, reason, and moral clarity. His work in cases involving corruption, civil liberties, environment, transparency, and judicial accountability has laid down the cornerstone for what we understand today as public interest litigation. And if you have ever had the privilege, like I have, to read his book, especially The Case That Shook India, you will know that his writing does not merely document history, it compels introspection. It's a text that is part courtroom drama, part political treatise, and entirely a call to constitutional conscience. To all our students present in the hall, I say this: you are truly fortunate Opportunities like this don't just add to your knowledge, they sharpen your constitutional sensibility. I urge you to listen with undivided attention, jot down your questions, write freely, and ask bravely. Your queries will be taken up during the interactive segment after the lecture. To our virtual audience, please share your thoughts and questions in the chat. We will be sure to carry them forward into the dialogue. The theme for today, reimagining the Constitution, future reforms and emerging trends, is as forward-looking as it is urgent. Because the Constitution, like democracy, all in service of constitutionalism. So with immense respect and admiration, I now invite Senior Advocate Mr. Prashant Bhushan sir to take us through this critical journey of constitutional foresight and reform. Let us listen, let us learn, and above all, let us question. Thank you. Please, sir.
Thank you very much, and good morning to all the faculty and students. I hope my voice is coming clearly. Is it clear? Okay. Uh, it's indeed a pleasure to be here to talk about our constitution and what its deficiencies remain and what kind of reforms are required. So, the essence of the Constitution can be found in the preamble of the Constitution itself as to what our Constitution makers were setting out to do, what they were trying to do. So, it says that we are creating a secular, socialist, democratic republic, and we are promising all our citizens justice, social, economic, and political equality of every kind, uh, uh, liberty, and fraternity. So, these are the basic foundational principles on which our constitution is based. And for this purpose, there is an important chapter on fundamental rights, in which the most important fundamental rights are Article 14, which is equality, uh, then Article 19, which are various civic rights, that is the right to free speech, the right to assembly, the right to free movement, etc. And then there is Article 21, which is the right to life and liberty. Now, Article 21 was though written out in bare bones in the Constitution, but over the years, the Supreme Court, which has been given the duty of interpreting the Constitution, has interpreted Article 21 in a very expansive way to mean not just animal life and liberty, but a life which is dignified and everything that is required for a dignified life. That is the right to basic food, the right to shelter, the right to water, etc. And that means the right to lead a dignified life. And in order to protect our democracy, to protect fundamental rights, we created various institutions. The most important institution that the Constitution created was the judiciary, primarily the Supreme Court and the High Courts. And they were given the power not only to strike down any law, any government action, any rule which was violative of the Constitution or the fundamental rights of people, but also given the duty to ensure that the executive and the legislature remain within the bounds of their power and the executive does its duty. So these are the jobs which have been given to the High Court and the Supreme Court by our Constitution. The second most important institution is the Election Commission, because in order we created what is called a representative democracy. We did not create a direct democracy in the constitution. And therefore, in order to ensure that in this representative democracy, elections are held freely and fairly, we created an election commission whose job is to ensure free and fair elections for the purpose of for protecting our representative democracy. Then among the important institutions, we also created a Comptroller and Auditor General. And the Comptroller and Auditor General has been given the duty to protect public finances in the country. That is to audit all the expenses of all governments, central government, as well as state governments, as well as public sector undertakings, etc. So, in order to ensure that public money, that is people's money, is not wasted by the governments, is not stolen by way of corruption, etc. So, that is also a very important institution. So, then, of course, there are one other important principle of the Constitution is federalism. So we created a democratic republic, but a federal democratic republic. That means we have the Constitution created and gave certain powers to the central government and certain other powers to the state governments and the state legislature, certain powers only to parliament, certain power only to state legislatures. Certain powers were later given by way of a later amendment to the local bodies. And then there are certain powers which are in the concurrent list, which can be jointly exercised by the center and the state. Of course, the Constitution also provides that if there is a law in the concurrent list or if there is a subject in the concurrent list, then if the center makes a law, that is, if Parliament makes a law which is in violation of some state law, then the parliamentary enactment will override the state enactment. So, therefore, while we created a federal structure where we have the center, states, and then local bodies, but we have vested, the Constitution has vested most power with the center, that is with Parliament, then lesser power with the states, and then even lesser power with the local bodies. This is the scheme of the Constitution. Of course, there were certain things which are not mentioned in the Constitution, that is the creation of various investigative agencies like police, like the CBI, Enforcement Directorate, etc. They have been brought in by various parliamentary enactments. They are not part of the Constitution. There is a Police Act, there is a CBI Act, there is a Act dealing with the Enforcement Directorate, etc. There is an Act dealing with the Central Vigilance Commission, and so on. So these are also important agencies which, though they have not been created by the Constitution, but they have been created by various laws made under the Constitution. Now, so this is the broad scheme of the existing Constitution. However, if we ask ourselves the question as to whether all the ideals which were there in our, say, preamble of the Constitution, whether they are being realized, whether they are being fulfilled in our country today, the honest answer to that would be that, well, most of them are not. And the reason is, if you start first with just take the fundamental right of equality. Now, today what we are seeing is a kind of state-sponsored assault on minority communities. We are also seeing several discriminatory anti-minority laws like the Citizenship Amendment Act or like this new Waqf bill, which has Waqf Act, which has just come, etc. We are seeing various things. We are seeing lynchings primarily of Muslims on the streets, which are in fact not only condoned but sometimes promoted by the governments in control. So there is a all-out assault on equality. Similarly, we are seeing an all-out assault on liberty. There are lots of people who are languishing in jails, in Bhima Koregaon case, in the Delhi riots cases, etc. Some of our finest human rights activists are languishing in jail for 5-6 years at a time without even getting bail, which is a gross violation of their liberty. However, if you look at the expanded definition of Article 21, which the Supreme Court has said includes the right to live a dignified life, then we find that the vast majority of the people in this country do not lead a dignified life at all. In fact, vast majority of the people in this country do not have access to proper food, do not have access to proper shelter, and a very large and significant percentage of them do not even have any employment. Uh, there is also the conditions of the Dalits in the country remains still almost as bad as it was when the constitution was framed, and therefore there is still continuing gross discrimination against Dalits and the depressed classes in this country. Our democracy, you see, unfortunately, we created only a representative democracy. We didn't provide for a direct democracy where people could directly vote or have their say in deciding what kind of laws, what kind of policies they want. We only created an indirect democracy, representative democracy, where we vote to elect our representatives, and thereafter our representatives, that is the members of parliament, etc., form a government, and then that government and the parliament decide what kind of laws, what kind of policies would be put in place in this country. But we are now seeing that there are serious problems even with our electoral system. We created an election commission which was supposed to be independent and impartial, which was supposed to ensure free and fair elections, but we are now seeing that that election commission, the fairness of the election commission has also been seriously called into question, and it appears to be acting as a partisan instrument in the hands of the ruling party. Same thing, we are seeing that the judiciary is unfortunately, by and large, not being able to guarantee the protection of fundamental rights of citizens. And one example of that is that for six years, some of our finest human rights activists have been languishing in jail without even the trial beginning and without their getting bail. So this is a failure on behalf of the judiciary to protect the right under Article 21, the right to life and liberty of so many people in this country. In fact, the majority of the people in jails today are still under trials, and many of them have been languishing in jail as under trials for decades altogether. This is a gross failure of it's a gross violation of the Article 21 rights, and it's also a gross failure of our judiciary, who has been tasked with the duty to ensure that fundamental rights are protected, our democracy is protected, and that the executive functions within the bounds of its powers laid down by the laws and by the Constitution. So, if you look at the Comptroller and Auditor General, whose duty is to audit the finances of states and the center, etc., we are also seeing a failure on the part of the Comptroller and Auditor General, or we are seeing that the CAG has also started acting for many years. It remained very independent, but in recent years, we have seen that its independence has also been called into question. And we are seeing that the audits of those states which are controlled by the ruling party at the center are hardly being done. And those only audits of those states are being done which are controlled by parties which are in opposition at the center. This is an unfortunate fact that we are now witnessing across the board. In, of course, the total number of CAG audits of the center have come down drastically. They have come down to almost 1/4 of what they were, say, even 10 years ago. But so this is a trend that we are seeing. So there is a serious problem with the working of our constitution. It is unfortunately not being able to do what it was designed to do. Can you just switch on the AC? So, so what do we need to do? What are the reforms that are required? Let us start first with the reforms in Article 21 rights. So, Article 21, right to life and liberty, Supreme Court expansively interpreted it to mean the right to live a dignified life. However, that needs to be enshrined in the Constitution itself. We need to specify that the Article 21 includes the right to have basic food, the right to have water, the right to have shelter, and in my view, it should also include the right to have basic employment, at least at minimum wages. This is one basic reform that we need to make in our constitution. Secondly, while we provided for a representative democracy, we have not provided uh, for any kind of direct democracy. We should have, and we should provide for at least some forms of direct democracy in our constitution. In most countries of the world, there is a system of initiative and referendum where people can directly say that they want this particular law, this particular policy. That is, if 10% people of, say, any population, let's say of the center or the state, make an initiative that, look, we want this particular law, say the Lokpal law, and then the government or the authorities are obliged to put that initiative to a referendum of the people. And if the majority of the people vote in favor of that referendum, then that issue itself becomes law. Of course, you can't have an initiative which is opposed to the constitution. So suppose somebody brings an initiative saying that we want that Muslims should be deprived of their right to vote. Now that initiative is against the constitution. Therefore, that initiative cannot be put to a referendum. Only those initiatives which come within the bounds of the constitution can be put to a referendum, and there the matter does not have to go to parliament. So this was some measure of direct democracy which we could have brought. Secondly, we have a sort of inverted power structure where the maximum power is with the center, lesser power is with the states, and least power is with the local bodies. In fact, this power structure should be reversed. We need to decentralize power so that maximum power remains with the local bodies, so that all issues dealing which have to do only with local affairs must be decided only and exclusively by the local body. All issues which have to do with things within a particular state must be decided only by the state. All issue and only those issues which affect several states should be decided at the central level. So we need to invert this whole power structure and decentralize power, and that should also be part of our reforms in the constitution. Then we need serious electoral reforms. You see, apart from having some form of direct democracy and decentralization of power, we also need very serious electoral reforms, which, in my view, can be engrafted in the constitution itself, should be engrafted. One is an obvious thing, that the power to choose the election commissioner and the election commissioners cannot be solely with the government, which is the case today. It has to be by an independent selection committee of the kind which is there, let us say, for choosing even the CBI director, the Prime Minister, the Leader of Opposition, and the Chief Justice of India. Some such independent or somewhat independent committee should choose the election commissioners. And this should be provided in the Constitution itself. Unfortunately, it has not been provided, with the result that the government alone is choosing the election commissioners, and they are choosing election commissioners who are partisan to the ruling party. Then, see, today, elections have become a game of money. The role of money in elections has increased so greatly that what we are seeing is a vicious circle, that those candidates or parties who are able to spend a lot of money, only they are able to get elected and come to power, and those who are not able to spend much money, they virtually have no chance of getting elected or coming to power. And this has happened because when we have got first past the post at two levels, when we vote for the candidate in our constituency, that candidate who gets the maximum number of votes gets elected. He becomes the sole representative of that constituency. Even if the other candidates together have got 3 times as many votes as the winning candidate has got, the winning candidate, even if he gets only 25% of the vote, if nobody else has got more than 25%, he becomes the sole representative of that constituency. After that, when the government is formed, that party or coalition which has 51% seats forms and controls the government. With the opposition, even if they have 49% seats, they count for nothing in the running of the government. Therefore, when people vote, they know that only one candidate will win and only one party or one coalition will come to power. Therefore, they don't want to waste their vote, and therefore they don't vote for a candidate or a party that they really like if they feel that that candidate or party has no chance of winning. If they feel that it has no chance of winning, they feel that by voting for that candidate or party, they will be wasting their vote, and therefore they will judge which party or candidates have some chance of winning, and among them they will choose the lesser of the two evils. This is how people vote. Now, how do they judge which party or candidate has any chance of winning? That judgment is made on the basis of visibility of the candidates or the parties. And visibility is largely purchased by money. So, a party or a candidate with a lot of money can put in a lot of advertisements in the media. He can put up a lot of hoardings across the constituency, across the country. He can even organize large political rallies by paying people to bring in the crowds. And then the media shows that this person held such a big rally, and therefore he is certainly in the contention for winning. And that is why, you see, the elections have become a game of money to a very large extent. So we need some political reforms which can be brought in through even the Representation of People Act, or it can even be put in the Constitution, which will reduce the role of money in elections. Now, originally it was thought in the Representation of People Act that you put a limit on the spending by candidates, and that would reduce the role of money in elections. Unfortunately, though that limit, let's say for Lok Sabha is 95 lakhs or something like that, we are seeing that individual candidates are spending 20 crores on each parliamentary election. And the reason why they are able to do that and get away with that is because they spend their money in cash and the election commission is unable to or unwilling to catch them. Now, this could have been dealt with by providing a simple amendment to the Representation of People Act, which said that all candidates and political parties can only take money and spend money through banking channels. And anyone caught taking money or spending money in cash, this will be considered to be a corrupt practice for which the candidate will be disqualified. You know, when demonetization was brought, the government said, or the Prime Minister said, that I want a cashless society. Now, you can't make the ordinary people cashless because poor people can't be expected to have their transactions only through banks. But at least political parties and candidates contesting elections could have been made cashless by this simple law. That would have stopped this abuse of spending 20 times in cash. Secondly, while there is a limit on candidates, there is no limit on political parties. For example, in the last 5 years, the BJP got 16,000 crores by way of political donations. If they put up 500 candidates for 500 constituencies, their candidates in all put together can spend maximum 500 crores in the Lok Sabha election. But if the political party can spend 16,000 crores, that is 30 times of what the candidates can spend, it makes a mockery of the limit on election expenditure. So therefore, we should have put a limit on the spending by political parties. But we have not done that, and that is also something that needs to be done. Then, another reform which should be there and should be part of the Constitution. See, we shouldn't just have only voting at individual constituency level in the manner in which we have. We should also have at least 50% of the candidates of people being elected through proportional representation. In proportional representation, people vote for their favorite political party. And in addition, they can also vote for their favorite candidate in that political party. So there, the system is that the party gives a list of candidates in order of 1, 2, 3, 4, etc. And the people vote for the political party of their choice, and they can also cast one vote for candidate of their choice within that political party. At the end of the day, the votes of all the political parties and candidates within that political party are put together. And if a party, say, receives 10% vote, then 10% of their people get elected, and not necessarily the first 10%, but the 10% who have got the maximum votes within that party. So in that way, we then know that if I am voting even for a smaller political party which cannot come to power as such, I at least know that my vote does not get wasted. Even if I am voting for a smaller political party, even if that party gets 5% vote, at least 5% of their candidates will get elected. So that's another reform that needs to be made. And lastly, we also need to have state funding of elections. Today there are many candidates, very good candidates, who can't even spend 95 lakhs, which is the limit on expenditure. Now, in order to enable them to spend at least that, whatever, 50 lakhs or 75 lakhs or 90 lakhs, you can have state funding of elections. The way that this works is as follows. You say that every candidate after the election will get 50 rupees from the government for every vote that he receives. And therefore, if a candidate gets 1 lakh votes, he will get 50 lakhs from the government so that he can borrow from his friends, etc., before the elections and then repay them after the elections from this money. Now, some people say, no, how will the government pay 50 rupees? This is too expensive. Just calculate. Total number of votes cast in a general election, Lok Sabha election, is about 60 crores. 60 crores multiplied by 50 rupees is 3,000 crores. That is not much money. That is actually peanuts compared to the kind of expenditure that is spent on a general election. So we can easily have state funding of elections. These are the electoral reforms that we require. Then we need serious judicial reform. See, there are 4 problems today in the judiciary. One is the problem of access and delays. 2 separate problems. Access, that is, ordinary people cannot access the judicial system. They can't afford lawyers. Now, the second is the problem of delays. Now, to some extent, there was a Gram Nyayalaya Act which was made in 2010, which was supposed to create these Gram Nyayalayas at the sub-tehsil level. Today, we have civil courts at the tehsil level. Below that level, at the block level, there were supposed to be Gram Nyayalayas which were supposed to deal with ordinary cases of most people. These were supposed to be informal court systems which could be accessed without even the help of lawyers. Informal systems, of course, presided over by judges. Judges to be appointed in a regular way with the help of the high courts, etc. But the procedure was supposed to be less formal so that people could access these Gram Nyayalayas even without the help of lawyers. And if these Gram Nyayalayas had been made, they were supposed to have been at least 6,000 Gram Nyayalayas in the country by now. Today, unfortunately, we still have only 300 or 400 Gram Nyayalayas. If 6,000 Gram Nyayalayas had been made by now, that would have eased both the problems, the problem of access to the judicial system as well as the problem of delay to a very large extent. The Law Commission has been saying for many years that we need to increase the strength of the judiciary. Our judiciary is totally inadequate. That is why we are seeing that cases don't get decided for decades altogether, that courts keep adjourning cases. 100 cases are listed before every judge on a single day. Therefore, we need more judges, more courts. But instead of having more judges and more courts, what we are finding today is that 30% of the existing strength of the judiciary remains vacant. There are 30% vacancies even in the existing strength of the judiciary. Then we have a problem of selection of judges. So, judges at the lower level, in the lower judiciary, are selected usually through some exam system conducted by the high courts or conducted under the supervision of the high courts, or sometimes through the state public service commissions. And judges in the High Court and the Supreme Court are selected by a collegium of senior judges, and thereafter finally the government has to notify that. Of course, the government has the right to return the recommendation once. Thereafter, if the collegium reiterates the same recommendation, then the government has no option but to appoint them. What we are finding is that there are problems in judicial selection both in the lower judiciary as well as in the higher judiciary. In the lower judiciary, there are all kinds of problems. I have been dealing with so many cases involving selections of the lower judiciary, very, very serious problems. We need to set up a really high powered body for selecting judges at for the lower judiciary, and a high powered full time body for selecting judges of the high courts and the Supreme Court. These need to be full time bodies which are completely independent of the government. That National Judicial Commission law which had been brought had ex officio members, that is, sitting judges, law minister, etc. These people are very busy people. They have no time to devote to this job of selecting judges in a proper manner. And there needs to be a transparency. There needs to be considerable transparency in the matter of selection of judges. So, therefore, these are also important reforms which need to be brought in the judiciary. They can be brought in through the constitution. They will probably have to be brought in through the constitution. Then we do not have proper accountability of judges who are committing for judges who are committing misconduct. Today we only have the system of impeachment, and impeachment we have seen is an impractical system. It just doesn't work. No judge has been successfully impeached so far. It's a political process to begin with, and also ends with a political process by voting in both houses of parliament with 2/3 majority, etc. So it's a totally impractical system. There is an informal in-house mechanism which has been devised by the judiciary, but we have found that that system is also not proper, and it depends on the whims of the Chief Justice in place at that time whether to activate that mechanism on a complaint or not. And I have found that on many cases, many serious complaints that even we have sent to the Chief Justices, successive Chief Justices, those complaints have been ignored and no inquiry has been done through the in-house system. Therefore, what we need is a full-time judicial complaints commission in this country, which is independent of the government as well as of the judiciary. Totally independent body which may have some retired judges and some eminent public figures, but it needs to be a full-time body with a investigating machinery under their control, to whom people can address complaints against judges, and they should have the power to investigate that matter, hold a trial of the judge, and thereafter decide what needs to be done. Lastly, there is a problem of independence of the judiciary also. In recent years, we have seen that the independence of the judiciary has crumbled to a very large extent. And one of the reasons of that is that we have this system of giving post-retirement jobs to judges, and many of these post-retirement jobs are controlled and influenced by the government. This is not proper, because if the government decides or has a say in deciding which post-retirement job should be given to which judge, they are able to influence the pre-retirement judgments of those judges. This is not proper at all. Then, unfortunately, this government has also has virtually frustrated this whole collegium system of selection by not issuing notification for appointment of judges that they consider to be inconvenient, with the result that they normally notify only those appointments which they find convenient, or usually just sit on those recommendations and then ask the collegium ki, all right, you appoint some of our people, then we will appoint some people that you have recommended, and thereby they are able to influence the independence of the judiciary by getting their own people selected, etc. So this also needs to be firmed up, and it should be provided very clearly that once the appointments committee makes the selection, then the notification would automatically be issued, and it cannot depend on the whim of the government not to issue the notification of appointment, etc. Then, as I said, in the election commission, we need the appointments to be made not only by the government but also by an independent committee, which may be Prime Minister, Leader of Opposition, and and the Chief Justice of India. There is also a problem of this electronic voting machines. Today, there is a lot of suspicion. In fact, just yesterday, Tulsi Gabbard, who is the National Intelligence Director in America, she has tweeted that they have found that in the electronic voting machines in America, there has been a lot of hacking and therefore tampering with the voting there. And the same thing can happen in India. I'm not saying that it has been happening, it can happen in India. And therefore, what we have been suggesting is that these, see, the Supreme Court directed that all these EVMs should also have a VVPAT machine where a paper slip comes out and goes into the box so that you can see that the paper slip is going for the candidate that you have voted for. But those paper slips are not being counted. Only 2% of those paper slips are being counted. Only in 2% cases does the Election Commission count those paper slips. Otherwise, the election is declared on the basis of the EVM results. Now, there is no reason, no earthly reason why all these paper slips should not be counted. And in fact, the system should be that when a person votes, the paper slip which comes out of the VVPAT machine should be given in the hand of the voter to deposit in a ballot box so that thereafter these paper slips are counted. So, this is a reform that needs to be made in the EVM VVPAT system also. Then there is reforms in the CAG. Of course, the main thing needs to be that the appointment cannot be in the hands of the government alone. It has to be in the hands of an independent committee in the CAG. And then there is this issue of various police agencies and investigating agencies, the police as well as various other specialized investigating agencies like CBI, ED, NIA, and so on. Firstly, the appointments, of course, there was a police reforms judgment of the Supreme Court which required that the appointment of the DGP should be done in a particular manner which will not leave it totally under the control of the government, etc. That unfortunately is being flouted in various states, and DGPs are being appointed by the government in violation of the prescription provided by the Supreme Court. But I think there needs to be further reform in that, and all DGPs of all the states should also be appointed in by the same selection committee of Prime Minister, Leader of Opposition, and Chief Justice of India, or some such independent body. It should not have any predominant control of the government, etc. Then another important thing in that police reforms judgment, this was a 2006 judgment of the Supreme Court, was that there should be separation between the investigative wing of the police as well as the law and order wing. So the investigating wing of the police is essentially part of the criminal justice machinery of the country, and that needs to be further insulated from the control of the government. Investigations should be almost totally independent of the government, because that is like being part of the criminal justice system. Therefore, government should not control those. Today, unfortunately, the government controls those, and therefore that's another reform that is required. So these are broadly the important reforms that are required. As I said, most of them should be made through constitutional amendments. Some of them can be made through amendments of laws, etc. But these are some things which need to be done. So I'll stop here. If people have some questions, I am happy to answer those for the next 10 minutes.
Thank you so much, sir, for that session. That session was indeed very insightful. Thank you for your insights. Now, I would like to request few students if they have any questions.
Yes, sir. Myself
Yeah.
is sir, I would like to ask you that what are the constitutional values, in your opinion, that must stay unattended, untouched regardless of any reform or rewriting the constitution?
No, the existing values enshrined in the preamble should remain untouched. They are perfectly fine. I am just elaborating on some of the further reforms that are required. So, democracy, sovereignty, uh, secularism, socialism, they should all be part. Justice, liberty, equality, fraternity, they are all important values. So, the preamble of the Constitution itself enshrines all the important values of the Constitution, and they should remain untouched, in my view.
Good morning, sir.
Good morning.
Sharma, I would like to ask you, in your view, does the Indian Constitution still reflect the aspiration of people in 1950, or has the time to come reimagine its core principle in light of contemporary critics?
I have not quite understood your question, unfortunately.
So, in your view, does the Indian Constitution still reflect the aspiration of the people?
Does the Indian Constitution what? I have not still not followed.
So, in your view, the Indian Constitution still reflects the aspiration of the people?
Yes, yes, I think the Indian Constitution still reflects the aspiration of the people. I just feel that it is many of the things provided in the Constitution are not being implemented. And they are not being implemented because of the failure of the various institutions which were created to implement those aspirations or to implement those values. And we need to reform those institutions in order to strengthen them.
Thank you so much, sir. So my name is Asna, and my question to you is that do you believe there is a need to explicitly constitutionalize the emerging rights, such as right to privacy, digital dignity, or environmental justice, means rather than leaving them to judicial interpretation?
Yes, some of these rights should be enshrined in the Constitution itself. For example, the right to food, the right to shelter, the right to water, even the right to employment should be enshrined in the Constitution. Now, environmental protection, yes, it can also be enshrined. Environmental protection, uh, uh, putting in place anti-corruption systems. So, India is a signatory to the UN Convention Against Corruption, so we can enshrine that also. All these have been interpreted by the Supreme Court to be part of Article 21 rights. So they can be explicitly enshrined in the Constitution too.
Firstly, sir, thank you for enlightening us with your knowledge. So my question is that would you agree that the evolving judicial interpretation of the Constitution itself constitutes the silent process of reimagining?
So तुम लोगों की for some reason I am not hearing you very clearly. That's why I asked whether my voice is coming clear or not. I am not being able to hear you very clearly.
Sir, my question is that would you agree that the evolving judicial interpretation of the Constitution itself constitutes the silent process of reimagining?
Yeah, of course. See, everything cannot be explicitly laid down in the Constitution itself, and that is why the judiciary is there to interpret the Constitution. And on the whole, the judiciary has done a good job in at least interpreting the Constitution and expanding Article 21 rights, etc. Unfortunately, the judiciary has not done that good a job in protecting fundamental rights or even sometimes in protecting our democracy. So, but on interpretation, the judiciary has done a fairly good job in interpreting the constitution and even expanding Article 21 rights, which I think it has done very well. I, I'll have to stop here because I have to go somewhere. Anyway, one more question, one last question.
Am I audible?
Yes, yes.
What are your views on freebies? It is a way of social welfare by government, or it is just a way to lure voters and put the burden on state finances?
What are my views on socialism or secularism? What did you say?
What are your views on freebies given by the government?
Freebies. Okay. So, freebies, you see, the thing is that in a socialist republic where majority of our citizens don't have access to many things, uh, freebies can be given. Of course, they should be provided by a law. They should be enshrined in a law. This kind of discretionary giving of freebies just before the elections, this should not be allowed. This is a way of bribing the voters just before the elections. If it is enshrined in a law, then it should be allowed and it can be allowed.
Thank you so much, sir. Thank you for responding to these questions. Thank you so much for being with us today. And this session was indeed very insightful. We really had an enriching experience, and we hope to see you soon physically with us in the campus. Thank you so much, sir.
Thank you. All the best to all of you.